Most people think a will is enough to protect their kids, but I have seen it firsthand: families torn apart, inheritance wasted, and predators circling the moment assets are transferred. I'm Ali Talai, and I'm a trust and asset protection attorney here in California, and I help clients make sure their legacy ends up in the right hands without court battles, sibling disputes, or reckless spending. In this video, I will walk you through a smarter way to structure your estate so your heirs are protected not just from outside threats, but from their own bad decisions. Because without the right guardrails in place, even the best intention can backfire, and the money you leave behind might do more harm than good. Let's talk about why legacy planning in California really matters. All right, so let's cut to it. In California, even the most well-meaning inheritance can turn into a mess. I see it all the time. Mom and dad work hard, save up, and want to leave something behind for their family, but with no real plan or the wrong plan, we end up with heartbreak, confusion, and the kind of family drama you see on TV. Worse, your heirs might lose their inheritance to creditors, lawsuits, divorce, or just plain bad judgment. California, as you probably know, is unique in few ways. We have strict community property rules, high property values, and a court system famous for slow and expensive probate. If you want to make sure your legacy goes where you intend and nobody squanders it or loses it to outsiders, you need to get serious and protect your heirs from themselves and others. Let's talk about preventing family fights and broken relationships. You would be amazed to know how many families stop talking after someone passes away. In California, if you die without a solid estate plan, your assets go through probate. That is a public, court-driven process, and it can drag out for a year or more, sometimes much longer. The court decides who gets what, and if just one family member disagrees, it can get pretty ugly. I once helped a family in San Diego. The parents left the house and some savings to 3 children, but there was no written plan, just vague sort of promises. One sibling wanted to sell the house, the other one wanted to live there, and the third one thought it would be best to rent it out. The probate court did what it had to do, but in the end, the family barely spoke to each other again. Here is how you can protect your loved one from that pain. Create a living trust. In California, a living trust avoids probate for most of your assets. The terms are private. You get to pick who will be in charge. And please be specific. Spell out exactly who is to get what and why you're giving this particular distributions to them. If there are unique family items or property, explain your reasoning in writing. Update your plan as life changes. New marriages, divorces, births, or major purchases can all affect your legacy. If your plan is clear, specific, and legally sound, you're giving your heirs the best chance of staying united and the least chance of fighting in court. Let's talk about protecting inheritance from creditors and lawsuits. California is the lawsuit capital of our country. Your heirs could be sued for just about anything: car accidents, business debts, or even unpaid medical bills. If they inherit assets in their own name, creditors can come after that money. Take the case of a client in Los Angeles whose daughter inherited a rental property. Within months of her inheritance, she was in a car accident and got sued for hundreds of thousands of dollars. If the property had stayed in a properly structured trust, like an inheritance trust, creditors couldn't have touched it. But because it was left to her outright, it was unfortunately fair game. Here's what you can do to shield your heirs. Use spendthrift trusts. In California, a trust with the right spendthrift language can block most creditors from reaching trust assets. Choose a responsible trustee. Pick someone who can manage and protect the assets, especially if your child is young or inexperienced. Consider lifetime trust. Instead of giving everything to your child at age 18 or 21, you can keep it in a trust as long as it makes sense, and sometimes it could be their entire life. That way, your hard-earned assets don't become a target for lawsuits, divorce settlements, or bad business decisions. Let's talk about guarding against ex-spouses and divorces. Here's a tough truth. California is a community property state. That means if your child marries and then divorces, anything they inherit might be at risk if it gets mixed with marital assets. Think joint bank accounts, paying off shared mortgages, or commingling funds. I will never forget the San Diego County client whose son went through a divorce 5 years after inheriting a substantial sum of money. Because the inheritance was deposited into a joint account and was used for family expenses, commingled, the ex-spouse argued she had a fair claim, and unfortunately, after a long court battle, she got a significant share. That was never what the parents wanted. So you might be asking, how can you keep your legacy safe from ex-spouses? Do these things. Keep inheritance in separate trusts. In California, as long as inheritance is kept separate and not mixed with community property, it belongs solely to your child. Add clear instructions. Tell your heirs not to mix their inheritance with their spouse's assets. Put it in writing. Have a conversation with them. You could also require in your trust that before any allocations or distributions are made to your child, preferably into their separate trust, inheritance trust, that they're required to obtain a pre- or post-marital agreement. A little planning can keep your assets in the family and not in the hands of a former in-law. Let's talk about protecting heirs from themselves, bad habits, and bad decisions that they may make. Sometimes the biggest risk to your legacy is your own loved one. Maybe your child struggles with addiction. Maybe they are easily influenced. Maybe they just aren't good with money. Here's the story that hits home. I worked with a family in Beverly Hills where one of their adult son had a history of gambling problems. The parents knew that if their trust provided a lump sum inheritance to this particular son, it would disappear within months. So instead, we used a discretionary trust where a trustee, not the son, could decide when and if to make distribution to cover things like rent, tuition, healthcare, education, but we didn't hand over a blank check to the son. So what are your options in California? Discretionary trust. Give your trustee the power to decide how and when funds are to be spent. Staggered distribution. Not my favorite option, but it is. And the staggered distribution is realistically a trust that says at a particular age, you give them outright distribution. 1/3 at age 25, another 1/3 at age 30, and then the rest at age 35. I don't like that kind of distribution, and I'll tell you why. The reason is, how is it that you're supposed to know what your child is going through at age 30, 35? And imagine that the trust says at age 30, they get 1/3 or half of the inheritance. And obviously, this means that the parents has already passed away. If the child turns 30 and you're alive, they're not getting any distributions. But if the parent has passed away, now the trust says you get half of the assets at age 30. And let's say your child is going through a divorce, is going through a lawsuit because of a car accident. The last thing they would want is an outright distribution while they're going through some sort of a trouble. A better plan, what I would suggest, is that we set up an inheritance trust and then we state a particular age that your child becomes the trustee of his or her own trust. Let's say at age 30, the trust does not have any requirement for any must-shall distribution. It's more of discretionary. The trustee may make distributions. And so the reality is that if they're the trustee of their own trust and they want to make distribution or they want to take distribution, they can take distributions. But if they're going through some sort of a lawsuit, divorce, bankruptcy, obviously they would not want to take any distribution, and the trust allows for that, and it doesn't make any distributions to them when distribution is not wanted. All right, let's talk about planning for special needs and vulnerable beneficiaries. If you have a loved one with disability or serious health challenges, ordinary inheritance can actually do more harm than good in California. If they qualify for state or federal assistance, like Medi-Cal or SSI, receiving money outright can make them lose those benefits. So here's what you can do. Set up a special needs trust, sometimes referred to as a supplemental needs trust. In California, these trusts are designed to hold assets for disabled or vulnerable heirs without making them ineligible for benefits. Pick a careful trustee. Choose someone who understands the rules and can keep careful records for government agencies. Work with a professional, an attorney that has experience with trust and special needs planning, and someone that can really design the trust to make sure it avoids any costly mistakes. This way, you can provide for your loved ones extra needs, things like tutoring, home care, or special equipment, without risking their medical care or housing. Now that you've heard these stories and options, let's talk about how you can actually put these protections in place. So you do this. First, inventory your assets. Your home, savings, retirement accounts, business holdings, personal items. Next, think about your heirs, their strength, their weaknesses. Then talk to a California trust attorney, I know a good one, who really understand legacy planning and asset protection planning. Every family is different. The right attorney will listen and then build a plan just for you, just for your family. Don't wait for someday. Too many families come to me after a crisis when choices are limited and damage is done. The earlier you act, the more options you have, and the more you can guarantee that your legacy supports, not hurts, the people you love. Now, if you're thinking about moving property into an LLC, or you have heard some great advice on asset protection, you don't want to miss my next video. Avoid this bad advice on moving property in California LLC. That's the title to it. There are some really common mistakes that could cost you thousands or land you in court. Click over to that video now and protect yourself from the pitfalls most people never see coming. See you over there.